Welcome back. On today's video, we're going to walk through a contract. This particular one that we'll start with is a rental contract, and I need to give you a obligatory disclaimer. I am not giving legal advice in this video. I am not an attorney. I'm not your attorney. I'm not representing anything legally. This just happens to be what I do on a daily basis, going through contracts. And what I find is a lot of people don't read them thoroughly or understand them. So I pulled down a lease agreement for a residential property, and I thought we'd walk through just the contract itself and pick out some things that I look at when I'm reading a deal. Contracts are part of our everyday life, and we need to make sure that as we're entering into contracts, we understand what those look like. Contracts range anywhere from renting an apartment, buying a car, getting married actually has verbal contractual obligations attached to it. Ask anyone who's been divorced if a contract is part of a marriage. And understanding what it is that you are obliging yourself to or making yourself responsible for is critical. So let's jump right in. This is a sample rental agreement. Let me blow that up a little bit so it's easier for everyone to see. And again, this came from, I want to say, a consumer.gov website. It is a boilerplate contract, and every rental agreement that I have seen has different components to it. So make sure you read it thoroughly and make sure you understand it very well. And we'll go over that part here in a minute. So any contract generally starts out identifying the parties. In this case, we've got the landlord and tenant. Sylvia Mando is a generic name that was inserted by consumer.gov. And it's talking about what the contract is for generally, or who's entering into the contract. So in this particular one, it talks about the date that it's entered into. As we go in, the date here is not necessarily the effective date, so we'll need to make sure we pay attention to that. Between the properties, landlord is agreeing to rent to tenant this specific unit in a property. Make sure that that matches up to the apartment that you're renting. We've seen errors there. And then under the following terms and conditions. The term of the agreement is July 1st through June 30th, 2023. Note that is not the date that is entered into. So it's signed here, but it's actually effective for this term. Then, upon expiration, the agreement rolls to a month-to-month agreement automatically. Now, if you're a tenant and you're not paying attention to this, I've seen people get up to June 30th, move out 2 days before or the day of, and they don't notice that if they haven't given 30 days advanced written notice, then they still are on the hook for rent. Rent is $685 per month. It talks about this being the base rent. Why does it say base rent? That's something you'd want to understand as you're reading through the agreement to find out if there's other payments that you're obligated for. The payment is to be made in this particular case in personal check, cashier's check, or money order. Newer rental agreements should have language in there that talks about it being able to be made via electronic means like ACH transfers, wire transfers, Venmo, whatever it happens to be. But if it's not, you may want to add it, because in this agreement, these are the only acceptable forms of payment. And technically, it may or may not hold up, but technically a landlord could say that it's not allowed via those other methods. And if it is made via those other methods, it could be late. Rent payment procedure. The rent is to be mailed to the landlord at this address, or in such other ways the landlord will advise the tenant. So the landlord could change this and say, well, I want to make it this way, I want to make it that way. The tenant does not have the choice in this agreement. If you need some other mechanism, or if you want to make a decision on how rent's to be paid, put it in this section. Rent due date. The tenant acknowledged the late payment will cause the landlord to incur costs. This is setting the framework for if this ever has to go to court. It's starting to lay the groundwork of why it's important to make these payments on time. They're saying they allow a 3-day grace period if it's not received prior to, that means before the 4th of the month. That would mean midnight, which is very hard to do. So whenever the close of business is for the landlord on the 3rd, if it's not received by that time frame, then the tenant pays a $25 late fee plus $5 per day until the rent is paid. There is no excuse, essentially, is what it's saying here, for late payments. Doesn't matter if you're sick, doesn't matter if you lost your job, financial emergency, nothing is an excuse in this agreement for making a late payment. Bad check servicing charge if the payment's dishonored or returned, meaning if the landlord deposits that check and the bank pulls it back out, then they're going to charge a $25 late fee, and keep in mind that is important, and whatever consequences there may be. So if the check bounces and the landlord is charged a insufficient funds fee or for a return check fee, whatever it is, you're going to pay $25 and whatever that triggers. Now, this could actually have some pretty significant consequences if the landlord is bad at managing their own money and they count on your money. So if you give the landlord a check, they deposit that check and use it to pay their mortgage or pay a bill, and the landlord's bill's check bounces and your check bounces, then theoretically the landlord could charge you the bounce check fee for your check and for his check and any future problems that are caused by your payment going bad. This language is very broad, so make sure you understand again what it is that you are saying or what it is you're signing. Security deposit. The tenant agrees to pay $685 security deposit to be refunded upon vacating. Now, that sounds like you're going to get your money back, but you have to read the rest very carefully. Upon vacating, returning keys to the landlord, and terminating this contract according to the terms hereunder agreed to. Now, what could that be referring to? Well, you have to give 30 days advance written notice, remember? So if you did not give 30 days advance written notice up here, then your rent happens to be the same as your security deposit, which means if you move out without that 30 days rent and you don't pay rent, they can take your security deposit and apply it towards rent. Some states will not allow that, so there will be some arguments in certain jurisdictions about whether that's allowed or not, but arguments have to be taken to court generally or to some sort of a tenant hearing board, and it becomes a hassle. So it's best to know the process and follow the process that you are agreeing to. The deposit will be held to cover any possible damage to the property. No interest will be paid on this money, and in no case will it be applied back to back or future rent. Okay, now that actually just negates what I just said. So it will not be applied towards back rent, which means if you didn't pay rent, it won't be applied towards that. And it will not be applied towards future rent. It is only being applied towards damage. That's good, but you're also not going to get interest on it, and it will be held by the landlord for at least 30 days, it says here. Some laws require they give it to you back within, or give it back to you within 30 days, but here it says it'll be held by landlord for at least 30 days after the tenant vacates the property. This gives the landlord, it says here, time to go through, inspect the property, assess damages or needed repairs, and then they will give you the deposit back minus any charges for, and this is again important to watch, missing or dead light bulbs, repairs, cleaning, etc. If you move out and there's a light bulb that is not working, they can bill you for the light bulb itself and the time the handyman takes to repair it. Again, most jurisdictions, yours may vary. Then they will give the money back to you. Here it says within 60 days after you vacated the property with a written explanation of the deductions. That doesn't give you really any option to dispute it. So what you want to do when you're going through this apartment is figure out, how do you document everything? Do you go through the property and do you make a detailed explanation of what you did? Do you take pictures? Better yet, do you take a video when you walk through so that you can refer back and say, no, that light bulb wasn't dirty. No, there was not a paint spot in that wall. No, we didn't leave holes in the walls. Whatever it is up to you as the tenant in this contract to make sure you have documentation. Cleaning fee. Those are always fun, and this is an interesting concept because I've had personal experience with this when I was living in an apartment. It talks about you accept the property in its current state or present state of cleanliness. Again, when you go through your apartment for the first time, or when you're entering into any contract, documentation is critical. In this contract, I would recommend that you go through and take a video of your apartment when you first move in. Note every defect, note every issue. Take a video walkthrough, do a 360 view of every single room so that, again, when you check out, if they say that this light bulb was not working, or there was a hole, or there was no holes in any of these walls, or there was no mold in the bathtub or mildew, all of those can come back and bite you if you don't have documentation. This also works with renting cars too, by the way. So they say that you will accept it in its present state of cleanliness and agree to return the property in the same condition. The only way to verify that it's in the same condition is to have documentation. or you will pay a $200 minimum cleaning fee. Now this is interesting because it says you will pay a $200 minimum cleaning fee if it's not in the same condition, and up here it gives them the right to do repairs. How do you marry up these two? Well, you've got to verify what the condition was, and having documentation is very, very important for it. We had a landlord once tell us that they were going to charge us a cleaning fee and they wanted us to clean the entire apartment. The argument we made was, well, if you're going to charge us a $200 minimum cleaning fee, then why do we have to clean the apartment? Because it conceptually says that you're going to do that for that $200 minimum cleaning fee, and we gave them the option to either give us the cleaning fee back or they could clean the apartment. Make sure you understand the argument that you're making, and you make sure you have documentation to back up the argument that you're making. Next, if you remove any of the property that belongs to the landlord, that could be light fixtures, doorknobs, that could be furniture if they put it there. It could be anything that's in the property or on the property that you're renting. If you take their property, then let's see, if anyone removes property belonging to the landlord, this constitutes an abandonment and surrender of the premises. Now that's really interesting, and I don't know if that would actually hold up. But essentially what this appears to be saying is if you take anything off that property that belongs to the landlord, that means you have abandoned the property and you're terminating this rental agreement. That actually seems to potentially not be legal, but remember, you are signing this and you are saying you agree to it, meaning you would have to go to court to fight it. That is a big, big deal, and you want to make sure you don't ever do anything to trigger that. Vehicles and garage use. The tenant agrees to keep a maximum of one vehicle on the premises or in the garage. One car, not two, not three, not five, one vehicle. These vehicles, now that actually seems to create a conflict with this over here because you get one and these is plural. Vehicles must be both operable and currently licensed. Park the vehicle in assigned spaces, keep those spaces clean of oil drippings, and not park boats, recreational trailers, other trailers on the premises without first obtaining landlord's written permission. I see this one get broken a lot. Someone buys a second car or a project car and wants to have the ability to and flexibility to work on it. Here you don't have that right, and you need to make sure that if you're going to do something like work on a car, that you follow the rules, because this becomes grounds for a landlord to terminate the lease if you break it. Most landlords that I know would not necessarily terminate this if you had a car that you worked on in the garage and you were cleaning up after yourself, but they could. So make sure, again, you understand what it is that you're signing up for. Utilities, residents are responsible for the payment of all utilities, telephone, gas, other bills incurred during their residency. They specifically authorize the landlord to deduct items of unpaid bills from their security deposit in the event they remain unpaid after termination of this agreement. So again, make sure that you're watching this and understand that if you don't turn off your utilities when you move, or if you don't have them assigned back over to the landlord, if it's in your name, they can take it out of your security deposit. This does then say that the landlord agrees to pay water, garbage, and sewer. So be clear on what it is that you are paying, and make sure that you are watching and doing that whole adulting thing and turning them on when you get there, turning them off when you leave, and get the verification or documentation of that. Services. Landlord is responsible for the following utilities: water, sewer, garbage and trash disposal. The tenant is responsible for these. So here it gives you the standard ones that you're responsible for. But then it also says all other utilities and services not listed under landlord's responsibilities. That could be things like in areas where there's snow, you are removing the snow because that is a service for some people. If it's not clear, do you have lawn care responsibilities? What are the other responsibilities that you're picking up here? You'll want to make sure that you have a very clear conversation. And if it were me and I didn't necessarily implicitly trust the landlord, I may write it in. If I was the landlord, I would absolutely write it in. Tenant acknowledged that landlord has fully explained to tenant the utility rates, charges, and services for which tenant will be required to pay. Now, here it's saying that you understand everything that you're supposed to do. If you don't, you should probably ask. And if there's any misunderstanding, you as the tenant are going to be responsible for it. So again, these are areas where you need to clarify what it is that you are agreeing to. This one's important. Notification of serious building problems. The tenant agrees to notify the landlord if there's any roof leaks, water spots appearing on ceilings, first sign of termite activity. The tenant's going to notify the owners if they discover any signs of serious building problems, such as foundation cracks, tilting porch, crack in plaster. Now, someone may say, well, gee, that's the landlord's responsibility, and why would I tell them that stuff? Well, here's why. If the tenant does not notify the landlord in a prompt manner, the tenant may be held financially responsible. That's why. You don't want your security deposit or to have a collector call you later because you didn't notify the landlord of issues. From the landlord's perspective, it's important to know if you have toilets leaking or leaks in the building so that you can get them fixed. It helps the tenant also because then you're not living in a moldy or a rundown place. So it does help to work together, but again, understand what it is that you are agreeing to. Pets in this case. It says pets are allowed only by obtaining landlord's written permission. So it's not just blanket they're allowed. In this particular case, you need to understand that you have to get the landlord's permission. When possession of the property is given to tenant, only those pets listed on the rental application will be allowed unless other written permission is granted. Pets do not include animals. This would be service animals trained to serve the handicapped, such as seeing eye dogs, hearing dogs, or service dogs. Now, there's a big difference between service animals and the ESVs that people get. But make sure that, again, you understand these issues. When permission is granted, the owners are required to pay an additional $25 a month pet rent charge for one or more. Now, this is where it really gets interesting because some leases are not well written. This one I've already started to see some errors throughout the lease, and they've assigned this to the wrong party, where they say permissions granted. Owners are required to pay $25 a month in pet rent charge. Well, no, the owners aren't required to pay it, the tenant is, but someone could easily argue here that there is no pet rent because the tenant is not required to pay the pet rent charge. So as you're going through contracts, you may pick up on little errors like that that are important. You'd have to go to court to potentially enforce them, but again, errors in contracts can obligate the wrong party to pay certain things. Also, you have to have a pet application sheet before move-in, so don't just sneak a pet in. If there's any problem, here it talks about how the landlord's going to handle pet issues. If there's a problem with a pet, there's several ways of handling it. If the pet's dangerous, it will not be allowed on the premises. So you may have to get rid of your pet if it becomes dangerous or if they think it's dangerous. In the event the owner, now it looks like they're changing the terminology here from tenant to owner, and this must be the owner of the pet. From a contractual standpoint, when you're drafting a contract, this is not how you do it. This is how some landlords who may not understand leases, and unfortunately consumer.gov, I would venture, does not necessarily understand how this should be handled based on this lease, and this may just be one they picked up also. But remember that you want it to be very clear what your obligations are and what the landlord's obligations are. Ambiguity, vagueness is not your friend when it comes to a contract dispute. Clarity is. Back to the contract, though. Let's see, in the owner being negligent in regards to cleanup or allowing access to areas the pet could damage, the tenant will be fined, or money will be taken from the deposit. So you could lose your deposit because of your pet. If the pet is a nuisance in any way, the landlord may make suggestions to how the pet is cared for or require the tenant to attend a training class to be approved by landlord. That's going to be very hard to enforce by the landlord. But again, understand that these are things you are agreeing to. So you could be forced to pay for a pet training course. You could be forced to pay for expenses from cleaning up pet stuff. Pet damage to the property, pet doo-doo in the yard, whatever it is. Pets are never to be allowed unsupervised in the yard. Cleaning up after a pet is necessary immediately following defecation, and constant barking will not be permitted. So you are responsible for all these items. The landlord doesn't have to tell you how to fix them. They can just tell you to fix them or get rid of your pet or leave. Those are all things that you may be signing up for by signing up for a pet. Full disclosure. This section is in pretty much all contracts, and it says that the people understand the whole contract, and this is the whole contract generally. So here, let's go through it. The tenant signing this rental contract hereby state that all questions about this rental agreement have been answered. First, a couple of nits. Number one, they're calling it two different things, contract and agreement, but it's saying that the tenant understands this entire contract. All questions about the contract have been answered. They fully understand all the provisions of the agreement and the obligations and responsible of each party as spelled out herein. So you are saying when you sign this, you understand it. You can't argue, I didn't understand, I didn't know what I was supposed to do, I didn't get it, I didn't, whatever it is, you are saying you understood. If you don't understand, don't sign. Get understanding before you sign. They further state that they will agree to fill all their obligations in every respect or suffer the full legal and financial consequences of their actions. So you understand, not only do you understand, but you are now responsible for, financially and legally, everything in this agreement. For your actions, and here's where it's really important, or lack of actions in violation of this agreement. So if you fail to do something, not just if you damage a wall, but if you fail to let them know there's a leak in the roof, if you fail to fix something that you should have fixed, you're also just as responsible. Signature signature by tenant on this rental agreement is acknowledgement that she has received a signed copy of the rental agreement, and that takes out another argument. You're saying you have a copy of this that you can refer back to. It doesn't give you the out to say, well, I didn't get a copy back. You're signing right here saying that you did get a copy of this, so make darn sure that you do. This is a very simple contract. You can see that how contracts and different portions of contracts have different implications, and it's very important that you do understand what it is that you're signing. Be that person that reads your contracts when you're signing them, when you're buying a car, when you're buying anything that you have to sign on for, when you enter into any sort of a contract, when you do a job application and a employment contract, read them. It's important because there's things within those agreements that can have lasting implications, and you don't want to be on the wrong side of that if someone ever comes after you. I hope this has been helpful. If it has, give us a like down below. If you'd like to see more content like this, consider subscribing to the channel. And if you know someone this may help, please do share. Thanks for being here. We'll see you on the next one.